How to win in the Colorado small claims court coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. So grateful to have you. I'm Jordan Farkas, and thank you to those who have subscribed since the last video and who have subscribed in general. If you haven't yet, please hit that subscribe button. It takes a second, definitely helps me to continue to produce videos just like this, but more importantly, helps you to win in small claims court, which is the goal of this channel. Don't forget to hit the notification bell as well so you don't miss a future video. For those who have not subscribed and or are visiting this channel for the first time and you wanted to learn a little bit more about me, I'm a retired small claims court attorney. I practiced for many years and I've authored several books on small claims court procedure. And to learn more, you can check out my bio video on the homepage of this YouTube channel. Now, today's video, I'm going to continue in my new, well, relatively new anyway, series on small claims courts across the United States of America. And this video is focusing on how to win in the Colorado small claims court. Now, of course, I am not a Colorado attorney. What I've done is my research online, just like you can do. And I don't claim that this is something that only I can provide. This is information that you can find out on your own. And again, that's part of what my channel is focusing on, helping you win in small claims court. That doesn't mean that I'm the only one with this information to pass on to you, but more it's about procedure and strategy and filling in the gaps, if you will. And also what I've done is I try and streamline what I find to be the most important points based on the various procedural rules and forms that I see on the various websites across the United States. But in terms of what I offer, not only, as I said, am I looking to streamline things for you to make things a little bit more digestible, if you will, bring things to you in more bite-sized pieces, but also as I go through these different procedures and forms that are required for the small claims court in Colorado, I'm also bringing from you my experience in terms of what maybe you should know or should not know, or what you should look out for. Okay, so without further ado, let's jump in. And for those who have watched previous videos, this is my trusty whiteboard over here, very old school, as I say all the time. The point is to give you a bit of a visual besides just looking at my face. But of course, you may be listening as you do some household chores or as you're working, whatever the case is. And I'm very grateful if you are doing that. But for those who are looking at me, I'm going to use this whiteboard as a visual. I know it's very hard for you to read the wording over here. I have to move over here just to get this into the camera view. Oh my goodness. I don't know if you can see the whole thing in the camera. I'll try and move out of the way. But the point is that I've written this down. This helps me go along with you in this video. It's kind of like a little bit of a notebook for me, but also to give you that visual. But if you can't read it, don't worry. I'm going to speak everything out. As well, if you've watched videos on other small claims courts and or you're not located in Colorado, you may wonder, well, why should I watch this video? But I think what I've learned from doing this series is that there is so much overlap between the various small claims courts across the states and also Canada, where I'm from. In fact, that's what I said in one of my earlier videos from the beginning, that obviously I can't be expert in every single small claims court's procedures and forms across the world, and I have to go research things just like you have to do. Although again, in terms of general procedure and strategies, I have a whole host of videos on my channel that will help you in that regard. But here, in terms of going through the different courts, what you can understand is that there's a lot of overlap between the various courts. So even if you're not located in Colorado, but you stumbled across this video, this should give you a good idea of what it takes to prepare and file your lawsuit and how to go about winning and also collecting on your judgment, because winning in small claims court is only half the battle. You actually have to collect on your judgment as well. But of course, if you're in California, and by the way, my last video, if I remember to link that above, I hope I'm pointing to the right place. It's either there or there. The last video was on the California small claims court. If you're in California, then you're going to want to know what your procedure is specifically to California, of course, whether it's California or Maine or wherever you are in the world. Okay, so obviously, take with a grain of salt the specific procedures for each jurisdiction. But overall, the idea of how to go about winning in small claims court and the various tips that I'm going to give you as I go through this video can definitely help you. But if you want to get more specific, then go to the specific video in your jurisdiction. Of course, as of the recording of this video in late February 2025, I've only begun this new series. I think I've done 4 or 5 small claims courts in the state. So if you don't see a video on your jurisdiction, your state yet, Don't worry, that will come. If you do want to see a video in your state, feel free to leave that in the comments below. As well, if you have any comments in general, if you are in Colorado and you're watching this and you feel like I left something out that's important, or you have a personal experience that you want to share, or if you have a question, feel free to leave that in the comments below as well. I have noticed that comments are starting to increase, and I'm grateful for that. And my apologies to those who haven't gotten a response yet. It is going to become more challenging as I continue to get more comments. And also, I don't always get the notifications, which I'm trying to figure out why that is. So bear with me, but I definitely appreciate all your comments, whether it's feedback, constructive feedback, positive, not so positive, or any sort of questions. I try and get to it as soon as I can. Of course, if you're watching this a year from when I'm recording this, for example, I may be up to a lot more comments where it won't be possible to respond to each and every comment, but I certainly try. And, as I continue to glance through them, if I see repeated themes of questions that people have that they'd like me to do videos on, I will certainly try to do that. All right, it's a lot of introduction. Let's get right into the meat and potatoes, if you will, of the Colorado Small Claims Court. It says at the top over here, how to win in the Colorado Small Claims Court. And for those who have watched previous videos, you'll know this. What I do is I go through general tips on the left side about how it works in the Colorado Small Claims Court. And on the right side over here, maybe my left, but on the right side of your screen, maybe, or maybe it's the left side. It's a bit, the way it's showing me when I look at my camera is kind of inverse. But in any case, in blue, anyway, is a description of the various forms in the Colorado Small Claims Court. This doesn't necessarily cover all the forms, but again, I've kind of cherry-picked the ones that I think are the most important, and you should certainly go to the guides of the Colorado Small Claims Court to learn the specifics, which, by the way, I will link you to in the description below. Okay, so starting off, what is the limit? How much can you sue for in the Colorado Small Claims Court? And the answer is you can sue for up to $7,500. I've underlined in value. Now, this is very interesting. So I talked about before how there's a lot of overlap between the various small claims courts across the world, or at least America anyways. I haven't gotten to the UK or anywhere else. But something that's interesting is that in most small claims court that I'm familiar with, you can only sue for an amount of money as opposed to like asking for an injunctive relief, like asking the court to do something or to stop somebody from doing something. Sometimes these are known as restrictive covenants. For example, you want the court to tell this person not to do something, or this business to do something or not to do something, or if, let's say, you want to recover certain property. It seems from what I've read in the Colorado Small Claims Court, you can actually sue for such things versus other courts where you can't, so long as the value doesn't exceed $7,500. So that's something that's very interesting to note. Of course, if you're not sure if you have the type of claim that belongs in small claims court or maybe higher court, maybe you have a claim for $8,500, which isn't within the limit. You may decide you want to waive the excess amount over $7,500 to sue in the small claims court because it's simpler, it's cheaper. You don't necessarily need an attorney. We'll get to that in a moment. But the fact is that you may want to consult with a local Colorado attorney to determine your options, and also make sure that the type of claim that you are filing is indeed one that's appropriate for Colorado Small Claims Court. But the bottom line is that what I've noticed is that it seems that Colorado is a little bit more allowing, less restrictive in terms of the types of claims that are allowed in the Small Claims Court. Now, I'm just going to jump. I actually wrote this closer to the bottom over here, but once I mentioned attorneys, I just want to jump to discuss that. And what the Colorado rules of procedure in small claims court state is that attorneys are not allowed. However, there's an exception. It's a pretty broad exception. If you do feel like you need an attorney, then you can give the appropriate notice of representation to the other side and file it with the court. I believe you have to file it, and you must have to file it within a certain amount of time, a reasonable amount of time before the trial, to say that you want an attorney. And then the other side can choose if they want an attorney as well. Okay, so it does seem to be pretty discretionary that even though the general rule is that attorneys are not allowed, you can decide that you want to get an attorney. And again, you can consult with a local Colorado attorney to see what their fees would be and if it would be worth your while to proceed with an attorney or not. So now back in order of my list over here. Jurisdiction. So where do you file your lawsuit? So I've talked in general in my other videos earlier that are posted in this channel about how it works, where you have to file your lawsuit, what the jurisdiction is, jurisdiction meaning where the lawsuit is actually filed. And the general rule, which again has a lot of overlap with other courts, is that you have to file where the defendant lives or works. But there's another place you can file, and that is where the property was located. So I mentioned before, if you're suing over a specific property or a dispute that arose over a specific property, then you can actually sue where that is. That may mean that you're talking about property closer to where you live versus where the defendant lives. So you should certainly explore your options to see where the best place to file is. But something to bear in mind, and I'm not going to go down this whole rabbit hole, and this is something to consult with an attorney on. Let's say you win in small claims court, and then you have to go and collect because the courts don't do it for you. You have to collect your judgment on your own. They say that winning is half the battle. The next half is actually enforcing, is actually collecting on your judgment. It may be relevant for where you file your claim, depending on where the defendant has property. So even if you decide that it's quicker to sue closer to where you live, because that's where your property is and that's where the dispute happened versus where the defendant may have property, that may preclude you from being able to enforce on your judgment. So it's definitely very important to learn these things before you go filing your lawsuit. Something else to bear in mind, which I didn't see so clearly on the website, but it must be contained somewhere in the rules in the Colorado Small Claims Court, is that there's the statute of limitations. So always bear that in mind. There's a deadline generally from when you can file your claim, depending on when the action or when your cause of action, when you had a reason to sue or when you suffered damages or when the invoice wasn't paid, etc., from when that occurred. Okay, so I didn't see that clearly listed. It must be somewhere there. Again, you could consult an attorney there. You can look more in depth at the rules. And again, I'm going to reference that in a moment, and I'll link you to general information about Colorado Small Claims Court. And if you continue your research, I'm sure you can find that. But just be mindful that there, in almost every court that I'm aware of, there is a deadline that you have to file your claim. Some places it's 2 years, some it's 6 years, some it's 4 years. And again, it depends on the type of claim oftentimes. So be mindful of that deadline. Don't let time pass. If you miss the deadline, or if you're getting close to the deadline or you're not sure, again, it's always, I know I keep saying this, but it's true. It's always best to consult with an attorney to see if what your options are regarding the statute of limitations. Obviously, if you think you've got like 1 day left, then you may want to just go ahead and file just to be safe if you can't get a consultation for another week. But by and large, assuming you have the time, it's best to consult with an attorney before you do anything, especially if you have a concern. Obviously, if somebody didn't pay you and it's 30 days later, you don't have to worry about a limitation period. I'm not aware of limitation periods that don't give you at least a year. Okay, that's not legal advice. That's just from my experience. Okay, but more, if certain passage of time, let's say, God forbid, you were sick and you haven't had a chance to deal with this, and now you're better and you want to continue with this lawsuit, you got to check to make sure you haven't missed a limitation period. Okay, you can't pull a Rip Van Winkle and sleep for 70 years and then go file your lawsuit. Of course, I'm exaggerating, but I think you get the point. Okay, now in terms of the rules that do govern the Colorado Small Claims Court, it is the Colorado Revised Statute, which is referred to as the CRS, as well as the Colorado Rules of the Small Claims Court. So I'm sure if you Google it, you can find it. If I remember, I'll try and link you specifically to these various statutes and rules so that you have it right here in the description. But these are the rules that govern, and it will be useful to go review this. I think in any court that you're in, you should always review what the rules of the procedure of the small claims court are in your jurisdiction. Of course, you're not a lawyer. Nobody expects you to understand as well as a lawyer would, but oftentimes these things are written relatively clearly. And if nothing more, at least you kind of get a sense and you get ideas. You can also take notes and jot down anything you don't understand so you can consult with a lawyer and know what questions to ask specifically, okay? But don't worry, nobody's expecting you to be a lawyer, but it's a good idea to look through these rules and procedures so that you know what you're doing. There's also various handbooks that are very helpful that I looked at as well before I did this video. And again, I will link you to that in the description. Now, in terms of how it works, when you file your, and I'm going to get into the form that you need to file, okay, in the form section, blue over here, but when you file your lawsuit, the court will give you a trial date immediately, which is pretty cool, okay? Because a lot of times in a lot of courts, there's a whole long procedure. You may not get a trial date for a year. I don't know when they're scheduling trial dates, but the fact is they give you one immediately, even if it's 2 months from now. I don't know, maybe it's 2 weeks. That depends on Colorado. I'm not sure how that works, but the point is that right when you file your claim, you get a trial date already. Now, what happens if you're not available for the trial date? Now, again, I didn't see this reference specifically. In most courts, you can ask the court for what's known as a continuance or an adjournment. I did see here that there's a form that deals with motion, so I'm sure you can make a motion to push off a date. So, for example, when the clerk gave you the trial date, maybe you were available, but something came up later that's unavoidable. Maybe, God forbid, there was an accident, whatever the case is. I'm sure you can make that request of the court. Of course, it's better when you actually go and file your lawsuit to come with your calendar so that you know what your availability is like. Bearing in mind, the defendant, when they get the form, they may say, hey, I'm not available on that date. It's my daughter's graduation or whatever the case is. So I'm sure there's ways that you can ask to change the date. So don't necessarily assume that it's set in stone, but still try and pick a date or ask the clerk to pick a date that works for you, assuming that you have discretion there. It could be that the clerk just picks one without telling you, but my understanding is that in most cases you can actually go with your calendar so that the date that you get is something that works for you from the outset. Now, in terms of delivery, I've talked about this a lot in other videos. Again, this is where there's a lot of overlap. You have to provide a copy of your form, your claim form, again, which I'll talk about there in blue, on the defendant. Okay, now the best way to do that, the court recommends, is to do it with a process server. That's a professional that serves the document on the other party. Of course, you can also, I believe you can deliver it yourself. I don't see why that wouldn't be an option, but you can use a process server. Usually they're not overly expensive as well. It really depends on your jurisdiction, obviously, and also how far the defendant is and how difficult the defendant is to serve. You can also do it by certified mail. The website says that that's not the ideal option because it can amount to delays, which is true. It's definitely always best to do personal service. Okay. Now, in terms of naming the defendant, also bear in mind, I have a whole video about how to properly name a defendant. It could be that the defendant, the person that you're suing, and again, I'm doing this video from the perspective of a plaintiff because most people going onto YouTube to research will be plaintiffs, people that are suing. But obviously, I'm not trying to not give love to defendants either. And oftentimes people are sued wrongly, and I recognize that, and I understand that, and you want to know how to win as well. So my goal is to continue to do videos from a defendant's perspective as well. But at least for these series, I'm taking the more majority and going from the plaintiff's perspective. Okay, so back to what I was saying. If you are a plaintiff and you're suing either a business or a government agency, there's different rules that apply there. So make sure to check out the rules of Colorado, and there are various guides on the website as well. So just bear that in mind. There's a difference between suing a business versus suing an individual, and also versus suing the government agency. Okay, I talked about attorneys already, and just getting to what I talked about before in terms of enforcement. Remember, the court does not collect judgments for you. It's up to you to go and collect on a judgment. And I'll talk about the forms here. You can send a certain form for interrogatories to the defendant and they become a judgment debtor. I didn't see that listed in the Colorado Small Claims Court, but generally when you have judgment, a person goes from debtor to judgment debtor, and a plaintiff goes from plaintiff to judgment creditor, right? Like creditor and debtor. Again, that may not be terminology that the Colorado Small Claims Court uses. A lot of other courts do, but whatever the case is, the person who has money owed to them can serve a notice of interrogatories to the defendant or the judgment debtor to get information about their assets. And in the event the person doesn't respond, a lot of times that will happen. If the person continues to not respond, there's something called a bench warrant. So the judge can even order somebody's arrest. In other small claims courts, this is known as contempt, like contempt of court. I'm sure you've heard that term from the movies or television. And in terms of the actual manner of collecting, like other small claims court, you can garnish bank accounts or wages up to a certain amount. I assume in most cases you can't garnish a person's entire wages because that's how they live. Also, you can't garnish certain social security benefits and things of that nature. In the Colorado Small Claims Court, I noticed, again, check the website and the various guides or consult with an attorney to learn more. There's also lien. I've talked about before in other courts, it's known as a writ of execution or a writ of seizure and sale of land, where you put a lien on a person's property, and that way they cannot sell their property until they pay you out, or if they sell their property, you'll be the first to be paid out. But most buyers, attorneys, when they're purchasing a property, are going to make sure there are no liens, and if there are, they're going to demand that the person with the lien on their property pays off the lien, i.e. that can be your lien from the small claims court judgment before the buyer is willing to actually close on the real estate transaction. So liens can be very effective. Again, I have all sorts of videos that talk about how to find out information about where the defendant is located, where the defendant has property, et cetera, et cetera. That's not the point of each of these videos in this series. This series is just to give more of an overview about winning in the various small claims courts across the United States, but not to get into the nitty gritty. I get more into the nitty gritty in other videos. And once again, you can always leave a comment or a question if you wanted to learn more about that. Now, in terms of the various forms, I may be repeating myself a bit from here because now I'm kind of going through this, but in terms of what the forms are in Colorado, and I'm trying to balance this on my shoulder because it always hurts me a little bit, despite the fact that I do work out. But in any case, the first form that starts your lawsuit is known as the JDF 250. It's called a notice of claims and summons, and it's pretty detailed, but something that it's important to realize is that you cannot attach exhibits. So a lot of small claims courts say you should attach exhibits meaning documents, receipts, photographs that can prove your claim. I know in Ontario, Canada, where I'm from originally, you can, and it's even advisable to do that in many instances, not always, but in many, if not most instances. But here, actually, you're not supposed to attach any of that. Those are things that you show up with to trial, which is a bit of a surprise because it means that both parties are showing up to trial not knowing what the other person's evidence is. I mean, you may have an idea, but it really doesn't allow for a lot of preparation, which can be very challenging. Like in Ontario, for example, you have to serve your evidence on the other side before you get to trial so that nobody's taken by surprise. I actually think that happens to help with settlement as well many times, because when one party realizes, whoa, this guy's got amazing evidence, they're more likely to settle versus just showing up the day of trial where anything can happen. But in Ontario, for example, as of the date of this recording, the limit is 25,000 Canadian dollars, which is a lot of money. So the procedures may be a little bit more onerous versus Colorado here, which is 7,500. So that may account for one of the reasons why the rules are a little bit more lax in terms of evidence. But in any case, this form, you should not be attaching any evidence. Just answer the questions on the form to the best of your ability. And then, as I mentioned before, you have to serve that on the defendant. Usually, it's probably best to use a process server. And then the process server has to go and file a proof of service called an affidavit of service, which is a part of this form, just to prove to the court that it was filed. And as usual, a defendant has a right to counterclaim against a plaintiff. So bear that in mind. If you're a plaintiff and you're suing, you may find yourself on the resulting end of a lawsuit as well. If a defendant says, not only do I not owe you money, but you owe me money. Of course, if the amount that the defendant claims is more than 7,500, that may take this case out of the small claims court. Okay, so there's all sorts of rules that can govern there. I'm not going to go down that rabbit hole again for the purposes of this video, but bear that in mind. And as well, the counterclaim has to be something that's really arising out of the same circumstances and facts of your claim to the defendant. Okay, now also there's an option for mediation, and the court goes through that on its website. That mediation is often advisable and recommended because a bird in the hand is worth two in the bush. Anything can happen in court. So do you want to risk it all and go to trial, or maybe mediate? The other benefit of mediating is even if you know you have a solid case, and you can never really know 100%, but let's assume that it is a solid case, you may not collect. So sometimes mediating and settling, let's say for $5,000, and also saving yourself the time and stress and aggravation of the whole small claims court process versus taking the full 7,500 may be worthwhile. Don't do things for principle. Don't, I'm not saying you should back down, justice. You deserve justice. Everybody deserves justice. But at the end of the day, a lot of times what it comes down to is dollars and cents. And a lot of times justice means taking the smart decision for your well-being, your family's well-being, and taking the 5,000 versus the 7,500. Again, I'm not saying that's right necessarily, and it's not right in every case, especially if you know the defendant has assets and you know where they are and you're not worried about collecting. However, in most cases, there's a reason why most cases actually settle. I don't know what those statistics are for small claims court, specifically Colorado small claims court, but in most civil procedure, at least for higher court cases, most cases settle before they ever get to trial. And that's the reason, because oftentimes it's better to know you have that certainty of a certain amount of money, even if you're losing the full amount. 75 cents on the dollar is worth more, is better than, losing everything. So that's mediation. And if you do mediate and you come to a settlement, then there's a form called the JDF 75 Stipulation where you inform the court. Okay. Otherwise, the defendant files their response on the form that you provided with them, and then you're off to the races. And like I said, the trial date is right on that plaintiff's claim form. The clerk gives you a trial date when you go to file your claim before you even serve it on the defendant. Now, some other forms you should be aware of, I've talked about this a lot in other videos. You want to have witnesses at trial who can corroborate your evidence, who can talk about what happened, if they have knowledge, obviously, personal knowledge of what happened. In most cases, if they're friendly to you, they're going to come voluntarily, but sometimes you're not sure and you have to secure their presence. That's called a subpoena, okay, SUBPOENA, and that's the form JDF 254. You want to serve a subpoena on the defendant to make sure they'll be there. But bear in mind, if you have to subpoena a defendant, that means they may not be too friendly to your case and they may not be the best witness for you. I've talked about this in earlier videos. So make sure to really consider if you want to subpoena a witness. I'm not saying you never should, but sometimes you have to be certain before you want to have such a witness. So that's subpoena. There's a form called a form 250, I think it's 252, forgive me. Again, these forms are all available and linked from the Colorado website, so you can check the specific number, but that's called a motion and order. Oh, that's called a motion and order for interrogatory. So I talked about that before. Interrogatories is asking questions, really like discovery, it's called in civil litigation. You're asking questions of the defendant, in this case, to determine what assets they have. This is after you get judgment, assuming you won in small claims court at trial and you want to collect and the defendant hasn't paid, then you can serve that motion for interrogatories. And I mentioned if the defendant doesn't respond on time or at all, then you've got the bench warrant that you can ask a judge for. How that you go about doing that, you'll have to check the rules and civil procedure because that's a bit beyond the scope of this video. By the way, there is a form if the defendant does pay. That's called a JDF. Again, can't really. It's a form. I can't read what I've written down here, but it's another JDF form that talks about satisfaction of judgment. Forgive me, it got a bit smudged. I don't want to stop this video. It just will make for a smoother video recording if I continue. But again, you can see these forms linked, and the point is that you should be informing the court that your judgment has been paid. That's the ideal situation, that you actually get paid easily and you file that form. It's not always the case, unfortunately. And we've also got, as I mentioned before, there's the idea of you could bring a motion. I don't know if I explained that clearly before. A motion is like an intermediate step before trial where you can request something of the court or of the judge. That's called the JDF 76. I'm assuming, again, it's an assumption. You have to check the rules and speak to an attorney in your jurisdiction. I'm assuming that one of those things you may bring a motion for is to ask the court for a continuance or an adjournment on a trial date, just to use an example. That's something where you would bring a motion. Okay, but there's all sorts of other examples that I won't get into over here. And then there's a response form called the JDF 81, I think it is, a general response where the person who receives the motion from you, in this case the defendant, can respond to your motion. And then finally, we have I mentioned before already, the JDF form 256, notice of representation, where if you feel like, hey, I want to have representation here, I want to have an attorney, and you've discussed it with an attorney, you've consulted, you know what the fees are, you know what your chances of success are, you know if it's worthwhile for you to get this attorney. Because again, remember, if attorney's charging you $2,500 retainer and the attorney says, I'm billing you per hour, and then you get to trial, and even if you win, you have to start paying the attorney to collect, and your whole case is $7,500, that's usually not going to be worthwhile. Okay, so make sure you're in a case where it makes sense to have an attorney. And if you do, you have to file that notice within the time prescribed by the law. Check the local jurisdiction and rules and procedures about that. So that concludes this video in our series of how to win in the small claims court of Colorado. I hope you found this video helpful. Once again, if you haven't subscribed yet, I'd be very grateful if you hit that subscribe button as well as the notification bell so you don't miss a future video. It will definitely help me as well to continue to produce videos just like this. If you know somebody who's having an issue, somebody's not paying them, or that you already know that they're going to small claims court or contemplating it, you could hit this share button underneath the video and share it with your friend, pay it forward. Of course, hit the like button as well. I always forget to mention the like button. Everything helps. And if you have any comments, feedback, questions, feel free to leave that in the comments section below. Thank you so much for visiting. For those who have subscribed, thank you so much again. And until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.